spend a couple minutes with you to talk about copyright infringement. Before I get started, though, I just want to make one disclaimer, and that is that this is not legal advice. This presentation is based on general legal principles of U.S. law, and even if I answer a question, I'm not giving you legal advice. Please don't say that you talked to an attorney and that she okayed whatever it is that you're going to do. It will not count. If you do have any questions, I advise you to consult your local counsel, which if you work in this building, it may be me or another attorney here, but just keep that in mind. So in the few minutes that I have, we're going to go over what copyright is, what copyright infringement means, how to avoid infringement, what this concept of public domain is, and then also we'll briefly talk about copyright considerations in social media, which Mabio already went over, so I'm just going to go quickly through those, and then hopefully we'll have some time for questions. But first I want to have a quiz, just to see where we're at and how much you already know about copyright. So I'm going to ask you questions. These are true and false statements, and you're going to respond. So please say true or false when I read the statement. So the first statement is, copyright protection is automatic once your original work is in a fixed, tangible form. Is that true or false? Okay, so it's actually true, and we're going to go over all of these in the following slides. The second statement, by making material available on the internet, the copyright holder has given permission to make copies and distribute it. Right, that's false. The third statement, if there is no copyright symbol on a work, then it is not protected by copyright. Good, false. Next, a copyright lasts forever. False. In order to publish copyrighted material that does not belong to you, you must obtain permission from the copyright owner. Is that true or false? Good, that's true in most cases, that is true. Next, if you alter copyrighted material, you can use it. False. Perfect. As long as you cite the source of a work, you can use copyrighted material. False. That is false. If you cannot find out who the copyright owner is, the material is in the public domain. Good, that's false. Keep that in mind. Okay, and the last one. You may be sued for as much as $150,000 for a single act of copyright infringement. This is true. So keep these in mind. This is why this presentation is important. So, what is copyright? A copyright is a form of protection that is given to the creator of an original work, and it protects works of original authorship that are in a fixed and tangible form of expression. So here are some lists of items that can be copyrighted. They include books, music, photographs, sound recordings, even architectural works. And the purpose is to give the creator control, and so they can get royalties for a period of time, and is to promote creativity. So not everything is copyrightable. For example, ideas, data, concept, discoveries, facts, titles, names, short phrases, and slogans, even though that second bullet point may be protected by trademark, those aren't copyrightable. Also, anything that's written or created by the US government is not protected by copyright. So who owns the copyright? Who's able to own these rights? It's the author of the work, or their heirs or assigns, or if they convey those rights to someone else, that person could also own the copyright. What rights are included when we say copyright? It means the right to copy and produce, the right to distribute work, the right to publicly perform, to display work, and this is a big one, the right to create derivative works. So for example, if you want to modify someone's work, they actually have the right to make any modifications. They have the right to change a book into a movie or to change a book into a play. The owner has these rights, and if you try to do any of these things without getting permission, you are infringing on the owner's copyright. So what is copyright infringement? I just kind of went over that. It is the use of copyrighted material either in whole or partially without getting permission from the owner of the copyright. Also, adaptation without getting permission is copyright infringement. And even if you get a license to use material, if you go beyond the scope of the license, that is still copyright infringement. So let's say that you're given permission to perform music at an event. and then you decide you want to record that performance and sell the recording, you've infringed. Even though you had a right to perform the music, you didn't have a right to sell or distribute the music. Or if you had permission to use a video on a website, but then you decide you want to make derivative works out of that, if you weren't given explicit rights to do something, you don't have the rights to it, and you are infringing. So as we discussed in the true and false fact slide, there are penalties for copyright infringement. The penalties, the statutory damages in U.S. law, they can range from anywhere from $750 to no more than $30,000 for each work. But if it's willful infringement, meaning that you knew that you were infringing on someone's work, then you can be fined up to $150,000, and prison terms are also possible. So let's talk about who can be held responsible for a copyright infringement. Well, the person or entity that directly infringed can be held responsible. Employees who participated in the infringement or should have known about the infringement can also be held responsible. And this last one's important, I think, for all of us. Anyone who publishes an infringing image or work, whether or not you have knowledge, you could be held responsible. And we've had instances of this where people have received material from someone else and they post it on their website, and that material included infringing images, and then they get the cease and desist letter saying you're infringing on our copyright. So it's important to kind of know what you're posting and what you're using. So how do we avoid copyright infringement? Well, the first thing I would recommend is determine whether or not the work you want to use is protected by copyright, because as we said earlier, not everything is copyrightable, and copyright does not last forever. And if it is copyrighted, get permission. Seek written permission from the copyright holder. Make sure that you have a license or release for all the uses that you want to use the material for. And especially if you want to create any derivative works, make sure that that is included in your license as well. So there are some works that do not require permission. For example, if you create your own work, then you do not need permission. It is yours. You have freedom to do whatever you want to do with it. You are the copyright holder. Also, material in the public domain, that is free to use. So that means that those are copyrights that expire, or creative works that people decide they want to place in the public domain on their own. Some people relinquish their copyright, some of their rights. And as we stated before as well, things that are created by the U.S. government are also not copyrighted, so therefore you don't need permission to use them. And at this point, any works that are published before 1923, in the U.S. at least, are in the public domain as well, so they are free to use. There's another type of work or time where you don't need to get permission, that is when your use of a work qualifies as fair use. I think, we talk about that later. So let's talk about the length of copyright protection in the U.S. Copyright in the U.S. lasts for a fixed period of time, and it depends on when the work was created or published, but at some point, all copyrights do eventually expire. So in the U.S., works that were created after 1978, the copyright lasts for the author's life plus 70 years, but works that were created before 1978, there are a whole host of different laws that come into play, and it depends if the work was registered with the Copyright Office, if they put proper notice on the copyright. So the important thing to do is to kind of check and see, maybe talk to legal counsel to see if copyright is still attached to that material. Whether or not the copyright has expired, it's really important to still give proper credit to the author of the work. So that's just a good common practice thing to do. So there's one other area where you don't necessarily have to give permission for use of a work, and that is the fair use exception. That is a legal doctrine that permits unlicensed use of copyright-protected work under certain circumstances. This does not apply to everything. It's actually in statute, and it applies to very specific things. It applies to criticism, commentary, news reporting, teaching, scholarship, and research. And it is fact-specific. Courts determine whether it's fair use on a case-by-case basis, looking at a number of factors. So my one piece of advice is to be careful if you're thinking, oh, this is fair use. It might not be fair use. And I don't think anyone necessarily wants to go to court to find out whether their use qualifies as fair use or not. So Mabio talked about this earlier in his presentation about copyright and social media, but I'm going to go over some of the same slides. When you're using social media, you may be giving up some of your ownership rights if you are posting material. So it's really important to read the terms and conditions before posting anything to social media. I'm going to go through some of the terms and conditions of Facebook and Twitter and Instagram just to show you some of the language in there, and Mabio did go over this, but the highlighted section says that basically when you post on Facebook, you're giving them a non-exclusive, transferable, sub-licensable, royalty-free, worldwide license to use any IP content that you post on or in connection with Facebook. So basically you're saying, Facebook, you're free to do whatever you want to do with this. So just be aware that if you're posting pictures, you're posting video, you're giving Facebook the right to use your material. Twitter is very similar. It says, you grant us a worldwide, non-exclusive, royalty-free license with the right to sublicense to use, copy, reproduce, process, adapt, modify, publish, transmit, display, and distribute such content in any and all media or distribution methods, and it says now known or later developed. So again, you're basically giving them all the rights that you have as a copyright owner, a non-exclusive right to all of those same things that you have. And Instagram is very similar. It says, you grant to Instagram a non-exclusive, fully paid, and royalty-free, worldwide limited license to use, modify, delete from, add to, publicly perform, publicly display, reproduce, and translate such content. So again, I'm just reading these to you so you can be mindful that when you're posting things online, you may be giving up some rights. So let's talk about best practices. I know this was a very short, quick presentation, but I really want to leave time for questions. I'm just going to run down these few best practices, and that is get permission from the copyright holder. And when you do have permission, then put that on the material. Say, reprint it with permission from blah, blah, blah. Give them attribution for their work that you're using. If you're working in video, make sure that you have permission from all the third-party material, including any music, including any photos that are used. You want to make sure that you have permission from everyone that's involved. And one way to take care of this is to search for works that are in public domain or to use your own work. Then you don't have to worry about the permission aspect of things. When you're posting things on social media, again, pay close attention to the terms and conditions. And also when you're entering into license agreements to use someone's work, pay close attention to terms and conditions. Find out how long the license is for. Find out when it expires. Is it for 5 years? Is it for as long as you need to use their material? Are you able to sub-license? Is there any restrictions on what kind of derivative works you can use their material for? And in all cases, again, give credit and attribution where possible. And one other piece of advice is when possible, if you are posting something online, if you're posting to another site, link to the original source instead of copying and pasting onto your site. Courts have found that if you link to a source, then that's not infringement, but if you're posting onto your site, then that could be seen as copying and that could be infringement. And the last piece of advice is to contact your legal counsel, not just when you just receive a demand letter, hopefully before you receive a demand letter, before you even post. If you have a question about something, it's much better to find out beforehand than to receive the demand letter afterwards. So I think I have about 10 minutes left. So if anyone has any questions, and I think they want you to wait for the mic, right? Or there's one right here.
What about I take a picture of a gentleman? Is it my photo? Who does it belong to?
So yeah, the photo is yours. Now, there's another area I was going to put in here, but I didn't want to start making things too messy. But there are also privacy concerns. But for purposes of who owns the photo, it's your photo. You're the photographer. You took the picture.
In Korea, there's one church. It's a Presbyterian church, and they have the office for the copyright for all the music, Christian musics. So they have the right to care for all the copyrights of the Christian music for all Asia. And so I wonder whether GC has such kind of office that can give copyrights for our churches around the world when they produce music videos or they produce some programs like praise programs or worship programs, because sometimes those other denomination copyright offices, they don't issue or give the permission to use those musics because of they have some prejudice against our church.
So if you're talking about, do we have some clearinghouse here at the General Conference that makes sure that we have all the proper copyrights? No. So here at the GC, our office will help making sure that we have permission for the departments within the GC to use material if they come to us. That's why it's important that if you're in another division or in a local conference, that you also seek advice from legal counsel there if you have someone there. And the other thing is that while I can provide, or we can provide advice for US law, it would be very difficult. Actually, I couldn't provide advice for use outside of the US, so that's why it's important to contact your local counsel as far as getting copyright permissions. And even if you ask for permission to use someone's work, they don't have to give you permission necessarily. So don't assume that you will get permission to use everything that you want to use. You can ask and they can say no as the copyright holder.
Thank you for your good presentation.
Thank you.
My question is, if I invite one doctor to make one interview to TV program, and the doctor brings some slides or some pictures for him, and I put this in the TV, this is a problem for me?
If you are, so one of my earlier slides said if you publish copyright protected work that you didn't have permission to publish, even if you didn't know it was protected, it's still infringement. So you want to check before you start publishing anyone else's material. You want to make sure that they have proper permissions before you start posting it either online or in your magazine or on television as well. That's something you want to protect for yourself because you could be held liable.
Thank you for your insights. My small question is on the context that we have here. Social media is quite fluid. I do acknowledge, of course, the points that you gave relating to the laws in this country. But as far as we are concerned, when you go the social media where you have gone into a small village where everything can matter, what advice do you give to people who are in scholarship academics, whether it's in social media or pure written documents, where you start up with a research where you fully document, whether it's from a website, whether it's from text, but then that research is picked up by other researchers and they make it so popular that it makes the original author somewhere to feel a little bit jealous and feel they should have a stake, but it's fully referenced. You know, you have done the best you can to reference everything that you could. In that case, what is your advice?
So just to make sure I understand the question, you're asking if you are posting something and you do give attribution, but then it gets picked up by someone else, what do you do? Or, well, first off, make sure that unless it falls under the fair use exception, and I've already stated that that exception is kind of murky and limited, so use that with a lot of caution. I don't advise relying on that. Make sure that you get permission from the author before you use something of theirs, unless it falls under the fair use exception.
Yeah. Probably the issue would be maybe the opposite of that would be true. This is where, okay, let me just speak from my point of view. I have the work, I have done it. You know, this is in a context of the church. This is where you are aware that, well, anything that I do within my work schedule or whatever, anyone can use it anyhow. But there are those things that are much more personal, that require your personal effort and all the like, whereby others may want to use it for personal gain. And in that case, sometimes we feel like, no, I think these people are not being fair to this individual. I don't know if you get my point. I think whether or not we like it, I think is very necessary. Whether it's in our preaching, whether it's in our singing, whether it's in this and that. There is a thin line, I know, but I think we need to be a little bit careful. Because in other countries, the infringement will not affect an individual. It might affect a collective group. In this case, the lawsuit sometimes affect the whole movement or the whole church.
Okay. So it sounds like you're making a comment there, so I'll say duly noted to that comment. Are there any other questions? I think we have time for one more or two.
Yeah. Copyright is really a tough issue, and from my experience, it's very easy to either get discouraged and decide not to do anything, or to decide not to care about it and just do whatever you decide to do. In this sense, I think it would be very helpful for the churches and for us to receive some kind of a guidance or resources. Where can we look to find easy solution to some of the problems we can face? For example, for streaming video in churches. For years, the problem has been, how do you deal with the music? So some churches just started after the music starts and just cut the sermons and so forth. And then hopefully now there is a good solution for this. Christian copyright solutions.
Yeah, CCLI license.
Yes, they provide this license, but it was difficult first to find this resource, and second to know. So this is a good solution. It's flexible. You just pay one-time fee, and you are covered for most of it. Still things that you have to look for, of course. But so in other areas as well, like for producing video clips or for pictures and so forth, it will be helpful to have something like this compiled that will help us. I think it will.
No, that's a good suggestion, so thank you.
you.
I think we have one more question, and then we're done.
I've seen people or entities that broadcast, distribute content have waiver forms where, you basically represent as someone that's performing or doing something that you are the owner of whatever material that you're bringing. Does that cover the entity that is doing the broadcasting, if I can use? I'm not trying to limit it to television or something like that, but you see what I'm saying?
I think it helps. But I also think that at the end of the day, it's not going to necessarily stop a lawsuit from coming, but it might be able to then say, well, actually, you should be suing this person. I don't know if it's actually going to stop you from being liable in the end, but it does help, because we actually do advise having that language in there saying that you warrant that you are you've gotten all the permissions that you need, and then we have indemnity language in there and hold harmless language in there. It does help, but at the end of the day, you should also, whoever is publishing or putting material out there should also be mindful that they can be held liable, and so you may want to go out there and just make sure that their permissions are correct.
Thank you.
So, thank you, everyone. And if you have any questions, I'll be around the rest of today, and you can find my information on the General Conference website. Thank you.